Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. We'll start our day in Lenawee County, Michigan. This is Judge Anna Marie Anzalone.
A note from Mr. Wendt on May 5th that he filed the noli with the court.
All right. Good job, Mr. Dagmar-Gozzi.
Hey, Judge, it was Mr. May doing all of it.
All right. But you could take credit for it. All right. So I believe Mr. Dagmar-Gozzi and the last person you have in front of me is Castro Olivares. I've got quite a few people lined up from the jail in front of him. Are you done in Judge Olsavers?
No, I'll probably pop over there and come back then.
Okay. Thank you.
Thank you.
All right. Who do I have joining me from the jail?
Chad Marvin.
Chad Marvin?
Yeah.
All right, let me grab your file. Mr. Fry, that's you, right? So in the matter of the people of the state of Michigan versus Chad Thomas Marvin, file number 25-22239FH. I have Brian Fry appearing on behalf of Mr. Marvin, and I need a prosecutor, please. I guess it's going to be Alexander Bayonetto appearing on behalf of the people. This is the date and time set for arraignment in this matter. Mr. Fry, have you received a copy of the felony information prosecutor's request for discovery and witness list?
Yes, I have, Your Honor. At this time, we would waive the reading of the information and we would request that the court ensure a not guilty plea and schedule this case for a pretrial.
How far out would you like a pretrial?
A few weeks.
All right. Well, I will enter a plea of not guilty on behalf of Mr. Marvin. And how about May 28th or June 4 at 8:30?
June 4, Your Honor.
All right. I will set a pretrial for June 4 at 8:30 in the morning because it was arraignment. My staff will prepare the notice of hearing. Mr. Marvin, you're also going to receive at the jail a advice of rights form. There's been a change in the law and we need those signed by defendants that you got a chance to review it and received it. So don't throw that away. All right.
Good.
Right. So I will see you back on that day. Thank you, Mr. Fry.
Thank you, Your Honor.
Okay. I am. I'm gonna take my files back real quick.
All right. Well, Judge Anzalone steps away for a second. Let's go say good morning to Judge McNally.
So you know, after you pay the 100 on PBT, you'll have to pay 105 on that. Then you can pay on that same day, pay $100 by May the 19th. And then I'm just going to give you until June the 2nd to pay the rest, okay?
Thank you, Your Honor.
If you need more time, you call the court, we'll go on Zoom, I'll give you an extension, no problem. Just don't ignore me.
Thank you, sir.
All right, you can pay this as outline though, you think, right? Okay, best of luck to you, thank you.
Thank you.
Where's Ms. Melton's file?
Do I have it? I can go get a judge.
People against Thompson, Anthony Wayne Thompson. 2514608, 2A, B, and C. Your name, sir?
Anthony Thompson.
So you should have been a lawyer. You did a good job for yourself here.
Well, I got a really spotless driving record.
Good.
And I drove and I knew I shouldn't have drove that car, but they were going to tow it if I didn't drive it. It ultimately got towed anyway. And I still owe $3,000 on that car and I can't get it out of the impound. So it's a costly experience to me.
So you have an unregistered vehicle charge, and you're gonna have to plead the driving, without valid registration, civil infraction. They're gonna dismiss the misdemeanor, and then they're also going to dismiss the equipment violation and no insurance.
Yeah.
Right?
Yeah, that's what she said she should do.
All right, to that charge. Is that what you want to do?
Well, I think that'd probably be my best interest.
To that charge of no registration, responsible or not responsible?
I am 100% responsible, Your Honor.
Jeez, I haven't heard anybody say that in a while. 120 is your total. I'm dismissing the driving an unregistered vehicle. I'm also dismissing the 2 civil infraction charges here of defective equipment and no insurance. Can you pay that today, sir?
If you can give me, I'm on disability.
That's fine. Just
Give me
tell me.
a little bit of time.
Yeah, how much time do you need?
Well, can we start payments next month? I get my checks on the 3rd of the month.
Absolutely. How much can you pay that day?
Well, I guess, how much is it?
120.
I can't promise you I'll try to pay it off, but if I can I give you $50 then?
You pay 50 per month. And I'll start that beginning June the 5th. How's that?
Thank you.
And if you don't have the money at any time, don't be scared.
No, I ain't scared. I'm not scared. I'm a pretty good citizen.
Okay, well, I'm just saying, if you don't have the money, just call the court. We'll go on Zoom, or you can walk in here.
Okay.
On or before the due date. I'll give you an extension. I don't care how many times we have to do that, okay?
Thank you so much, Your Honor. You have a wonderful day, sir.
Yeah, I wish you well. Good luck to you, sir.
Thank you very much. You all have a good day.
Thanks. You're very respectful.
Thank you.
It's nice to see
People
you.
should be that way. They ain't that way anymore.
Bobby Melton. People against Bobby Nicole Melton, 215-235-006.
Good morning, Judge Dion, Castillo, on behalf of Bobby Middleton, who was present. Middleton, can you state your full name for the court?
Bobby Nicole Melton.
Well, defendant pled guilty to possession of drug paraphernalia. They're just outright recommending jail. Are you aware of that, Ms. Melton?
I didn't,
They do that. They don't usually recommend jail. Go ahead. Have you reviewed the pre-sentence report with it, and are there any material additions, corrections, or deletions?
I did, Your Honor, there are no.
How long has she been in custody on this?
How long have you been in custody with Middleton?
Are you
I've been
listening?
here 2 weeks.
Yeah, you've been in here since the 24th, right?
Yes,
Is that true?
yes.
What are you gonna do to straighten out your life?
I'm trying to get this together. I am.
So, Your Honor, she wants to do inpatient treatment. She did,
Yes.
a reference number from Sacred Heart so that she could, so I would just be asking in lieu of jail time if the court would order inpatient,
Yeah.
treatment. And she also.
Ms. Mountain, why are you saying, yeah?
I'm listening. That's all. It's helping me focus.
I'm sorry, Ms. Patillo, go ahead. You're asking for patient treatment in lieu of jail.
Yes, Your Honor. She had that reference number set up through Sacred Heart, but she's been in custody, so she missed the time to set up the interview. Once she's released, though, if released, she does want to start inpatient treatment.
Why you been playing with us? This should have been done with a long time ago. This is from 2021. Are you aware of that?
Yes.
And you live in Flat Rock, right?
Yeah, we just moved back about a year ago.
And where were you before that?
Taylor.
Taylor, okay. So you weren't in Iron Mountain or Juneau, Alaska or San
No.
Diego?
No.
So you were within 20 minutes of here. Why haven't you been showing up, ma'am?
I've been in and out of my dad's. it's a lot. It's a lot.
What's a lot?
I've been in and out of my dad's. We had a house in Taylor, like I was saying.
Wait a minute, I lost what you said. You've been in and out of your dad's, you said,
In
right?
Taylor,
Then I missed what you said next.
And I've been in and out of my father's.
You said that 3 times. What else? I don't know what that means.
Me and him fight a lot.
Okay, well, maybe you should be more respectful to him. He's giving you a place to
Agreed.
stay, maybe you should be doing
Absolutely.
things. All right, go ahead, what else?
I've just been struggling with this addiction. That's it. I'm struggling, and it's hard. And I do want to help.
She also, 13-year-old child.
She also has a warrant out of the 34th District Court for DOUIL.
For what?
I mean,
I've been struggling with addiction a long time.
I don't really think jail really, at this point, she needs help. She doesn't really jail sentence, because once she's released from jail, if she's not rehabilitated, she's gonna be, they're back before your honor.
you have insurance, ma'am?
Yes, I have Molina. I have Medicaid through the state.
Calling Jessica. You got everything going on here. It's meth, crack, amphetamines. I mean, what?
I'm sorry, what?
You're using drugs like you're jelly beans. I mean, you got every color going on.
I need help.
All right, well, you should get yourself help. You're 33 years old, right? Or 30, you'll be 32 in
31.
November, right?
Yes,
Come on,
I'm ready.
you're ready.
It's not because I'm in here. I'm tired.
I'm tired. Tired too.
I've
Got
had.
it.
You teach me enough.
You don't really
I
want.
relapsed years ago. And I relapsed when I came home for Christmas, and I never should have came home.
You don't really want help, I don't think. You just don't want to be in the jail there.
No, that has nothing to do with it.
Well, Your Honor, she did have that reference number.
I really did. Before this.
So to get an interview, you have to call and get a reference.
Accents are pioneer.
Yeah, wait a minute, let me listen to your lawyer for a second.
Sorry.
To have an interview, you have to call and get a reference number from Sacred Heart, and then that reference number is the interview. She did do that before she was.
Your name?
Just going on preparation.
So she's been 14 days. She says she's on okay.
Okay, I don't know if her other case with Judge Hessen is holding her up though, I don't think she's released on that.
Tell me she paid, man, I'm not sure, but I don't know what the bond is.
Yeah, she's scheduled for a probable exam, I believe on, yesterday was a probable exam, then she's scheduled for an exam on the 13th.
The bond. What's that? Can you pull her up to, please?
Yeah, she also has a pretrial with Judge Hessen today.
So she's got a felony and a misdemeanor going on?
I'm gonna look right now. I just know she was on the docket for Judge Hessen today. I don't see a felony case. Oh, it was waived yesterday.
Is that the 25F 709-020?
Yes.
Why does it, oh, non-public, okay.
But Ms. Melton did indicate that she waived the exam. I don't know what the AOI and the circuit, what that date is yet.
What's the bond on that, Ms. Melton, can you tell me?
15,000, 10%.
Do you have any thoughts?
I mean, if she can't get out on that bond, I don't think there's a reason to give
I know.
her time served, just to give her time turned on this if she's not able to get out.
What's the charge on that?
Jaywalking and meth.
Jaywalking.
I got caught with meth.
I mean, it doesn't sound like she's gonna be able to post on it, so there's nothing I can do. I'm gonna simply do this. Ms. Melton, you need to get yourself some help.
Yes.
And judges really tend to not think people are sincere about getting themselves help when they don't show up for years. And then they pick up other cases, then all of a sudden, they want to get themselves some help. I'm going to give you 21 days jail credit, 14, serve 7 more. No fines, no costs. I wish you well. It sounds like you got bigger fish to fry. I sincerely wish you well. Thank you.
Miss Melton,
Thank you, Judge.
will you remind the deputy that you need to go to Judge Hessen's courtroom?
Jacob Robert Zrebick, 25D1481318 and B.
Good morning, Judge Deanne Pizzolo on behalf of Mr.
Jacob Zrebick.
Zrebick.
All right, sir, tell me your name again.
My name is Jacob Robert Zrebick.
You're another one that's got a lot going on here. So he's pled guilty to
Okie dokie. So the feed was getting a little bit crusty from Judge McNally, and now all of a sudden it's completely gone out. So let's go back to Judge Anzalone.
Mr. Matthew, good morning.
Yeah, Mr. Murphy. All right. This is in the matter of the people of the state of Michigan versus Caleb Robert Daniels. We have 3 files, 23-21311FH, which is a probation violation. Very sorry. We have 23-21356FH, which is also a probation violation. And then 24-22081FH, which is a new file set for pretrial along with a contempt of court. So I have Matthew Murphy appearing on behalf of Mr. Daniels and Isaac Sneed appearing on behalf of the people. Mr. Murphy, how would you like to proceed?
Your Honor, Mr. Daniels had a probable cause conference down in district court yesterday. Mr. Daniels, did you waive your exam yesterday on that file? So we wanted, I think that was something we talked about last time. We want to get that file up here and include it in a plea. I think that was a fleeing and eluding charge, which was he was arrested on spawning these cases. So, Your Honor, I think we're just going to ask to adjourn. I was hoping to have that processed on district by today, get it up here, but I don't think they've gotten it up here yet because it was just yesterday. So if we could just adjourn for 1 week, maybe, and get that file, get up to that file.
Mr. Daniels, did they tell you what day your arraignment circuit court is?
On the 14th, Your Honor.
All right, so what I'm gonna do is set all these over to May 14 at 8:30 in the morning. And Mr. Murphy will do the notice on the 2 violation of probations. If you could do it on the stip and order on the new file.
Yes, Your Honor.
And Mr. Daniels, we'll see you back on that day at 8:30 in the morning.
Okay, thank you, Your Honor.
Your Honor, could I have a brief breakout, Mr. Daniels, just for a minute?
Yeah.
Thank you.
Hold on 1 second. All right, Mr. Daniels. We're in jail Zoom 2. All right, go ahead and join that breakout room.
Miss Underwood would get her shit together.
Miss Underwood does have her stuff together, but she goes back and forth between 2 courts. So she's not just in my court, so she will be here in a minute.
I apologize, I was speaking to myself.
Well, If you're loud enough, I can hear you. You're talking to me.
I didn't know it.
All
I
right.
thought this was a little less sensitive than it is.
No?
Alrighty, while we wait for people to get their quote-unquote shit together, Judge McNally's feed's back up and running, so let's go back to that.
One of the conditions.
I already have a sponsor and a home group already.
All right. So you think this might help you? Maybe it's a wake-up call, huh?
Oh, it absolutely was a wake-up call. It was the second hour. The handcuffs were put on me, sir.
You have some work to do, though. I mean, you really do.
Yes, Your Honor.
You got all kinds of things going on here. So I'm going to place you on probation for 13 months. I'm going to take file B under 7411. The terms will run concurrent. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation after a court is direct. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. Kratom, poppy, CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order chemical tests, PBTs and ETGs, weekly for 3 months. If you're clean, I'll make it bi-weekly for 2. If you're clean, I'll make it monthly. You're to attend AA twice a week until you're in an intensive outpatient treatment program. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. So AA twice a week until an intensive outpatient. Once you get in, you can stop AA. You do the IOP with aftercare. You're also to attend the victim's impact panel. Again, I want to just reiterate, just so you're clear, weekly testing for 3 months. If you're clean, I'll make it bi-weekly for 2. If you're clean, I'll make it monthly. You know that. All right, now, you just have too much going on. This is concerning me. 4 days jail credit, 1 serve 3. I'll let you serve those by way of the court work program. There's a $35 a day court work program fee. So you have 105. All of those fines, the common fines I'm going to attribute to file A. So 3 days court work program in lieu of jail. On file A, pay fines $300, costs $200, 75, victim's rights fee $50, justice assessment 6 1/4, screening fees $60 for 685, probation fees are $260 for 945. You have court work program fees of $105. For a total of $1,050. You also have cost of recovery of $225. Your total's $1,275. I'm going to assess $40 in attorney fees, $1,315. That is on the drunk or operating while impaired due to the consumption of controlled substance. On the other file, I will simply go 100 fines. This is on the drug charge, 100 fines, 100 costs, 75 victims' rights, $50 justice assessment. 3 1/4. If you violate, you could get 93 days on the impaired charge. You could get 90 days on the drug charge.
Kazman, crusty like the clown, I think. Absolutely. Judge Fleischer just came online. Let's go say good morning.
Are you saying it belongs to him? What are you saying?
I believe it belongs to him or to the partner, the former partner. The leasees, the people that lease the actual premises.
Because if it belongs to the other person, then it's a criminal mischief. You can't break someone else's property.
But he's not the complainant. The complainant is the leasing manager for the apartment complex. They're alleging that the property belongs to the apartment complex.
Your Honor, from the DEMS, it says that each 3 trash cans worth $35 each. They're placed outside for residents to use for trash bags on all 3 levels of Building 8, causing the property to.
So it's like, it must be, cans that officers put out there in case anyone needs to put trash in or whatnot. You know what I mean?
Yes, sir.
As far as the interference is concerned, that I may have a problem with
I don't see how that was interference.
because what would they possibly put him in custody for?
So, Your Honor, just to clarify, I'm not, what the Dems say, and they go to the great lengths to explain this, is that there was a deputy there who was serving some sort of civil paper.
Sure.
And that he had to stop serving the civil papers to go
To chase him.
detain the defendant, because the defendant, there was a disturbance in the leasing office. And at some point during that disturbance, the defendant got away from the deputy who was serving the civil papers.
Correct.
It's not really clear from the information, is the serving the civil papers and having to stop that duty to go detain the defendant, or is it the defendant getting away from the deputy, if that's what the basis for the interference is?
And that's correct, Your Honor. Richard and I spoke about that this morning.
So you don't think there's PC on the interference?
I don't think there's PC on the interference, honestly, either way. If he's trying to serve papers.
I think I agree with you on the interference.
Yes, Your Honor.
But I think that there's PC to go forward on the criminal mischief.
Yes, Your Honor.
No?
I'll dump the interference.
So I'm going to find no probable cause to go forward on the interference. I don't think that they had a reason to, have you in custody or for you to interfere with.
Yes, sir.
I will find that there's probable cause to go forward on the criminal mischief. Is he staying there now or is he gone?
No, Your Honor. I think both individuals have moved away from the apartment
Okay,
complex.
so Mr. Eichelberger, the only thing I'm going to ask you now, or I'm going to order you, is not to go back to this place, not to have contact with the complaining witness.
I understand.
Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond, not to be in possession of weapons as well. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Brock and he'll tell you if and when you have to come back to court. Just stay out of trouble. Don't pick up any new cases. I don't want to have to put you in jail. You
understand.
become a danger to my community. It's not going to go well for you.
So, this is them. All right, looks like he's back up and running again. No, just froze again. Sweet. Let's go back to Judge Anzalone.
You have the right to have the court order any witnesses you might have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined, misconduct is defined but not limited to absconding, failure to appear.
All right, we caught that one kind of in the middle, and it looks like Fleischer's feed's back up running, so we'll go back there.
All right. Good morning, Ms. Gonzalez.
Good morning.
Ma'am, you're charged with terroristic threat of a family or a household member. That kicks it up to a Class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on March 20th, 2024 in Harris County, Texas, officers responded to a terroristic threat call. The complaining witness and the defendant are sisters, and complaining witness say the defendant is not allowed to go into a residence. The complaining witness's son mistakenly let the defendant and her husband in, and they drank the beer. The complaining witness texted the defendant about her being in the residence, and the defendant responded with threatening messages that said the defendant will slap CW and show up at, slap the complaining witness and show up at the complaining witness's job. The complaining witness stated she feared for her safety.
What the hell does that mean? It's got to be serious bodily injury, man. Or
Yes, Judge.
are we putting everybody in jail now for whatever?
Judge, that's really all I have.
Statute.
Sure.
probable cause, ma'am. As the old adage says, sticks and stones, right? Words will never hurt. They actually can. You have to be careful what you say, who you say it to, because it could end you, you could end up in hot water. I'm going to find no probable cause in this case. The idea also is that if you don't have a good relationship with someone, it's probably best not to just inject yourself repeatedly in there because you're asking for trouble,
Right.
I mean, you now know. All right, man, please. Just be careful, all right?
Your Honor, I'm filing dismissal.
Thanks. All right, ma'am, your case is being dismissed. If you want to copy the dismissal, you're free to wait. Otherwise, you're free to go. Okay.
All right, Judge, next is page 12. Guzman, come on up.
So real quick, while we're waiting for that guy to come up, let me know in the comments what you think of this. One of the biggest criticisms I see for Judge Fleischer in the comments of the videos is when he gives advice to people after he finds an OPC. What do you guys think of that? I personally don't see a problem with it, but a lot of people do.
Assault of a family member, you're also charged with driving while intoxicated. On the assault case, you're facing up to a year in jail and or a $4,000 fine. And on the DWI, you're facing up to jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 29th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle with an expired registration and initiated a traffic stop. The law enforcement officer made contact with the defendant driver and observed a strong odor of alcoholic beverage. The defendant admitted that he had an open container of an alcoholic beverage in the back seat and admitted to drinking 2 to 3 beers.
While driving?
It's not clear as to when the drinking occurred. I'll check further in the dim summary. The law enforcement officer found an open 16-ounce Miller Lite can, half empty and cold to the touch under the driver's seat. The law enforcement officer observed the defendant to have unbalanced and a strong odor of alcoholic beverage. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant consented to providing a breath sample and blew a .112 and a .111.
Okay, now we have an assault, right?
Yes, sir, that one is open. And we need
Whoa. Whoa, so that was an open case.
Listen, Judge. That one was a open warrant for a few months. A non-arrest.
Okay, do you mind reading me what happened on the assault, please?
Absolutely, Your Honor. On March 1st, 2025, in Harris County, Texas, officers were dispatched to a family assault. A law enforcement officer met with the complaining witness who stated that the defendant is her ex-boyfriend. The complaining witness stated that they got into an argument over the complaining witness's inability to make him a sandwich. The complaining witness tried to stop the defendant from leaving, but the defendant closed the door on her hand. Later, the complaining witness was holding her child when the defendant bit her, causing bite marks and a bruise. The complaining witness stated that the defendant has assaulted her before, but she never reported it.
Mr. Guzman, I'm going to find that there's probable cause to go forward with your case on both cases. I am ordering you can you look to see any prior DWIs, please?
Yes, Judge.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I would think that it's freaking elementary that you're not to have alcohol in the car while you are driving. I am now taking away your privilege to drive. You are not allowed to drive for any reason. I don't care where you have to go. I don't care what you have to do. I don't care that you have to work. I don't care if there's a burning building and you have to save 50 kittens. You get into a car and drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. If you do, Every single time that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand me? I'm also finding that there's probable cause to go forward on your assault case, and I'm barring you having any contact with this complaining witness. There is a protective order that has been issued in this case. Get to know it, because if you do something to violate the protective order, the state can and probably will file additional charges against you. A violation of protective order, and that is the capital murder of misdemeanors. Mr. Guzman, I'm going to protect every single person in this county, whether they're on the street, whether they're on foot, whether they're on the house. And if you become a danger to my community, I only have one place for you. And I don't know who you have in this life, but if I put your bond at 10 to 20,000, if you don't have anyone to pay it, you will be stuck like Chuck in there until these cases are over with. Do you understand?
Yes, sir.
Any prerogative, yes?
No, Your Honor.
Okay. Mr. Guzman, do you have the ability to hire a lawyer? I can have you fill out an application. I need to know everything about you. How much money you have coming in, what you're doing, what kind of car you have, any kind of retirement. I need to know everything about you, and then we'll take a look to see whether you qualify. Don't be a danger. Do you understand?
Yes, sir.
You get no more warnings. All right, Deputy Miranda.
Okay, so I just took a look. There is a McAllister's only about 10 miles from me, and I never knew it was there. There's only 3 in Arizona, it looks like. But so I'm going to have to go check that out. Thanks for the reco on that. It's funny, Wednesday, the first Wednesday of every month is actually Deli Sandwich Day here at the Courtroom Files bunker, but we always get the stuff to make our own. So that's dinner tonight. We've got to go shopping today, and we'll pick up all that stuff. But next time we go out, perhaps we'll check out McAllister's.
From Mr. Rucker. So, I mean, where is he?
Rooker?
Come up, sir. Take a seat for me in the jury box. You know what? I don't, have you reached out to her? This case is 435 days old, and I know that she has a lot of history with him. I'm ready to put these babies to bed. So appointing another lawyer, it's going to take another month or 2, and I don't want to do that. So. Who are you guys?
We're his parents.
Parents? Okay.
Can we talk?
Not yet. Let me get a lawyer.
Bailey, Subway is not worth driving for, even if you can legally drive. And this is from a guy who worked there when he was 16 years old. But that was back a long time ago when it was actually real food that they served there. Like, we sliced our own meats and everything else, and back before it was all done in a prefab factory. But anywho, potato salad is good too. Don't forget the baked potatoes. So yeah, we're gonna have to check this out. Maybe maybe I can talk Mrs. the Courtroom Files and Grandma the Courtroom Files into it for Mother's Day or something.
I'm not. I'm just not gonna mess it up. If you want to go to if you want to go on 37, it's fine. So no, I mean my stuff. Okay. If you want, if you have to check in with 37, it's
Ms. Gonzalez, if you want to come up, we can give you a copy.
Thank you.
Are we Judge?
Yeah.
Judge, I actually have 2 cases, but they're both off docket.
Okay.
One of them is, I'll give the cause number, it's 252-5198. This one, we were here on Monday. Okay, he needed to get the interlock, but he was out of town. My associate was here. You said you bond forfeited him. You said as long as he gets the the interlock.
remember, yeah,
Yes.
remember.
And then he's already filed a supervision order. And so if you could just reinstate him.
Did he get the interlock?
Yes, and he's already filed a supervision order.
Ready to go?
This is on.
I filed it, Your Honor. We signed the contract. I did file this.
Okay.
Yeah.
I mean, as long as it's good and you're filing.
It's filed it. I've already filed it. And probably should take my review. And then we should.
Okay, I'll ask, I'll let her know that you reinstated it.
I did yesterday, so we can fall through the.
Hopefully it did. I'll talk to her in a second.
Yeah, okay.
And my other one, Judge, is a walkthrough.
Gonna bring him up?
He's my walkthrough guy. Yeah, he's out in the hallway. Let me grab him real quick.
Do you need a translator?
Yeah.
Okay, yeah, please.
Do I have to call them and let them know?
She can and she cannot. What's your question?
For the protective order, it's still in effect.
It's still in effect,
Right.
correct.
Do I have
Yes.
to let them know about this?
Who?
They're gonna be able to know. Oh, your cases. Okay.
Yeah.
Thank you.
May we approach on?
Yes.
Okay.
And what is your cause number?
Okay.
256-1688.
You get it?
I talked to Marcus.
That's it, right?
Yes, Your Honor.
Shh. Okay, you are Kevin Vasquez.
Yes, Judge.
Mr. Vasquez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Yes, Your Honor. On April 14th, 2025, in Harris County, Texas, law enforcement officers assigned to a follow-up investigation for failure to stop and give information. The complainant advised law enforcement officers that the defendant pulled out of a parking spot and struck the complainant's vehicle in a Chick-fil-A parking lot. Complainant advised that the defendant left the scene without providing any information. Law enforcement officers went to the Chick-fil-A and found surveillance footage of the incident. Store manager stated that they recognized the defendant as one of their store employees who was on shift that day. Store manager provided the defendant's contact information. Law enforcement officers arrived at the defendant's residence and spoke to the defendant's mother, who confirmed the defendant had been driving the motor vehicle that day, but her husband was the registered owner. Defendant contacted law enforcement officers, provided his Texas ID and insurance information, and admitted driver of the motor vehicle on the date of the accident. Defendant stated he drove out of the parking lot and felt an impact, did not see anything on the ground, so he left and went home. Defendant stated he did not call the police or file a police report.
Okay. Can you run his license, please?
Yes, Your Honor. And one other thing, Your Honor, we did get a damage estimate back, just for the damage purposes.
Oh, how much? Right.
$5,000.
But
we've.
Yeah, we've talked about that, Judge, and we've watched the video and there's a lot of pictures of the
I
damage.
mean, it always depends on the car.
That's exactly correct.
Lambo.
That's why. It's an Audi, but it's a 2013 Audi. So I don't know, and it may be. So we'll figure it out.
I think we'll be able to.
Insurance?
I'll find out. I don't know if he has insurance, but I'll
So
find out.
according to the DIMS, the defendant had turned his insurance information over to law enforcement. I'm gonna talk to the complainant, see if there was anything filed, and maybe we do something with the deductible.
Sure. Do you see if he has a license?
Yes, Your Honor, I'll.
You're not allowed to drive, Mr. Vasquez, unless you have a valid Texas driver license and liability insurance in your name. That is a part of your bond condition. If you pick up another case, if I find that you're driving without either, I will revoke your bond and put you in jail. No more PR bonds. Do you understand?
Yes, Judge. It's eligible, Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with Marcos and he'll tell you if and when you have to come back to court. So do you mind filing those conditions and then Marcos sign it? We're going to have conditions for you to sign. Once you sign the conditions, after that, you'll be free to go.
You're right, that's just they're driving without a valid Texas license and
And no,
insurance.
and no insurance, right? So we need a bond because it's in warrant status now. Roxanne, do you mind giving me a PSR? And do you want the cause number? You have it? Okay. I don't know if I see anything. If barring no criminal history, I'll set the bond at $100. I'm going to give you a PR bond now, but like I said, you will not get any more. This is your one chance. You understand?
Is it?
Are you still employed at that Chick-fil-A?
Yes.
Okay, good. Okay, so he's gonna have a ton of paperwork to sign. We'll have you go to Victoria Sign and Resit now. Do not leave until you sign our bond conditions, then you have to meet with Roxanne for your PR. Okay, thanks, Mark. Appreciate it. Okay, just.
There's been an increased amount of violence at God's Chick in the last couple of weeks. I've seen across multiple courtrooms where Chick-fil-A seems to come up a lot. I don't know, some weird trend. Also, don't think for a minute that big tech doesn't know everything you're doing at any moment in time. I just got a push from YouTube Music to let me know that Fiona Apple has a brand new release that's out that I should give a listen to. The title of that release, Pretrial. So let's go give Judge McNally a try, see if his clown show feed has cleaned itself up while Judge Fleischer is quiet for the moment.
Things over at 2 different restaurants, or fast food restaurants, whatever. I want to make sure he's not driving.
He is not, and we're selling the car.
Pardon?
And
Nope, still a clown show. I tried. He's out of the rotation for the rest of the day now. Let's go back to Judge Anzalone. She still has people in cages she's trying to deal with. Yeah, here we go.
0 to 17. So that does not merit a prison sentence. Based on my conversation with Mr. Raymer, I believe that he is remorse genuine for this matter. Also, as I stated in my motion, that alcohol is, I think, the underlying factor. I believe if the court considers the criteria for release at post-conviction, I would argue to the court that clear and convincing evidence exists. This is not something that occurred with the public. It was with an interaction with the police. I believe the court can put in conditions for Mr. Raymer to maintain sobriety. I'm not aware of, in the prosecutor's response, that he missed the court date. If he did, our office was representing him at that time. I don't know if the court issued a warrant. These matters out of Missouri are a little concerning. I don't know if 2031 CR 05183 means that's a error. Is that a 2021, 2011 case? They all seem to be minor offenses. I'm not aware of there being a hold on jail for him there. I think Mr. Raymer would like an opportunity to show this court that he can be a productive member of society and that this is just a one-off here. And we'd ask the court to consider granting him a PR bond with appropriate conditions pending sentencing. Thank you.
Mr. Sears.
Your Honor, upon reviewing everything since post-trial with Mr. Raymer, our office is not too concerned with what you rule on whether to release him or not in the sentencing matter. We do believe every justice has been served with the trial and with the guilty verdict. At that point, to point out, upon review of public court records from Missouri, I just wanted to make the court aware that it does appear that he has, it's technically 3 bench warrants for failure to appear, but 2 of those cases are the same date, time, same incident. So, and then I believe the failure to appear was at the final pre-trial in December before the original trial was set for the 26th of December. Other than that, Your Honor, the people do not have too much more to add, and we'll leave the ultimate decision of this matter at the court's discretion.
All right. So thank you. In light of the fact that you've made the court aware that there is some dispute to guidelines, this matter is set for sentencing on June 5. I'm going to order that sentencing memos be provided to the court by both sides by May 30th. So obviously, Mr. Malaro will get that out so that he can file a response, so that way I can review it before the day of sentencing. Mr. Raymer, I appreciate what your attorney is saying in his request, but having sat through the jury trial and watched the body cam, and being required to hear you call police officers a fucking cunt, at least I think I lost count at 30 times. And the dangerous situation that occurred that day, I do find that your behavior was egregious, and that I do not have faith that you will not violate your bond conditions. So I am going to keep your bond or keep you remanded to the custody of the sheriff's department pending sentencing. Mr. Raymer, I will also say that you're not looking at a prison term, okay? So don't worry about that, all right?
Yes,
And
Your
then I
Honor.
want you to think long and hard. I mean, this has got to stop. All right, thank you, Mr. Weimer. We'll see you back on sentencing.
Would it be okay if I say something?
No, we're good. We'll see you back on sentencing.
Oh, thank you,
Shane,
Your
I'll
Honor.
come talk to you.
Thank
I'll
you.
come talk to you tomorrow.
All right, thank you, sir.
All right, thank you. Ms. Underwood, in the matter of the people of the state of Michigan versus Delshon Bomarito, file number 25-22196FH. Ms. Underwood represents Mr. Bomarito. Mr. Sneed represents the people. Ms. Underwood, how would you like to proceed today with Mr. Bomarito?
If I could just talk to him for half a second, Your Honor.
Yep,
You've
Mr.
spoken,
Bomarito, we have really good audio on today, so that's a good thing. So I'm going to assign Ms. Underwood and Mr. Bomarito to a breakout room. Mr. Bomarito, I think you'll go automatically and then I'll bring you back. But if you don't go automatically, someone might have to do it for you. Yep, he went automatically. All right, Mr. Lee, you'll be next. Thank you.
Okie dokie, while they're doing their thing, let's go back to Judge Fleischer.
As a sanction, she goes to Hawaii. If she violates, if she messes up, ends up going to Hawaii. But that would definitely, we could make that happen after that, right? So
Just volume shooting here. Can we put her on probation and violate her today and send her to Hawaii?
She has to be given like a chance to miss a.
Okay.
because it wasn't recommended.
Okay,
We have to go with what the recommendation.
Yeah.
Like they didn't recommend Hawaii, so that's.
Okay.
I know that it's probably. And I'm with you,
Okay.
but we can't.
Okay.
So
No, I'm
that's
just.
why we have to,
Given the time frame that everything happened and I have it labs, she just doesn't qualify right now.
Okay.
And Your Honor, just to, so we're in. You would only accept information off on this. Their time, their jail time.
I want her.
Yeah.
I get it.
We just-
I get it. I thought I'd just throw it out there.
Don't want to graduate with going upstairs, you know?
I get it.
Okay.
Let me talk to her and see.
I mean, really, that's a win on your behalf. She's not going to residential or doing anything now. We're giving her the opportunity and hopefully she can, do it the right way. So it's all up to her.
Let me go chat with her.
Thank you.
Thank you.
Right here.
Sure.
Oh, okay, yeah.
Sure.
All right, well, he's quiet for a moment. We can go back to Judge Anzalone.
Count one, assault of a prison employee with one supplement, Your Honor. Count two, and the remaining supplements would be dismissed. We would also be asking at this time for a COBS to the low end of the guidelines, Your Honor.
All right, any, is that Mr. Sneed, one, a correct recitation of the plea and any position on any Cobb's to the low end of the guidelines? You're muted, sorry.
That is a correct recitation, and the people defer to the court's discretion regarding the sentence.
Okay, thank you. All right, that's fine, Ms. Underwood. So is your, and your client's gonna avail himself of that plea?
He will enter that plea today, Your Honor.
All right, so Mr. Bomarito, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, and Mr. Bomarito, Ms. Underwood, with one offense notice, that would make it a 7.5 years, is that what that is?
I think it's
With one sub, what would be the maximum penalty, Ms. Underwood?
I think it's 6, Your Honor.
Well, it's a 5-year felony.
Okay, then, yeah, I do think 7.5.
Okay.
Yeah.
Okay, all right, so Mr. Bomarito, you've heard the plea offer that was placed on the record today. Is it your intention today to plead guilty to count 1, assault of a prison employee with 1 habitual offender supplement, which would make the maximum penalty up to 7.5 years in prison and or a $2,500 fine, with a Cobb's agreement to a sentencing at the low end of the guidelines, whatever that might be? So is it your intention to plead guilty to that count today?
Yes, Your Honor.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the court will Cobb's to the low end of the guidelines. Ms. Underwood, is that correct?
That's correct.
Is that correct, Mr. Sneed?
Yes.
And Mr. Bomarito, is that correct as far as you're aware?
Yes.
All right, sir, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Bomarito, do you understand, let me go back there. Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 3.10 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? So do you understand, Mr. Bomarito, if you commit another assault of a prison employee and are charged with offense, I will not be bound by that Cobb's agreement anymore. Do you understand that?
Okay.
They changed the law on that. So it used to be if something happened and the court wasn't going to honor a Cobb's or a Killebrew agreement, you would have the right to withdraw the plea. But the legislation has changed that now, and you wouldn't have the right to with absconding or failing to appear for sentencing, which isn't going to happen in your case, and violating conditions of bond or terms of sentencing. So basically, if you were to get another charge, that could be a violation of whether or not I Cobb's you to the low end of the guidelines. Do you understand that?
Yes, I do.
Okay, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Bomarito?
Yes, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Mr. Bomarito, as your attorney promised you what your sentence will be like in terms of guidelines or the minimum sentence?
No,
Okay, and it's your own choice to plead guilty,
yes,
and you're satisfied with her as your attorney and the advice that she's given you?
yes, Your Honor.
All right, so Mr. Bomarito, on October 5 of 2024, were you at the Gus Harrison facility located in Lenawee County, Michigan?
Yes, I would.
All right, would you agree that that facility is located in Madison Township?
I believe it's located in Adrian.
Well, we call it Adrian, but it's actually located in Madison Township. Would you agree to that?
Yes,
Okay, and you were an inmate at that time at that facility?
yes,
And you had been sentenced and you were serving a term there, correct? So you were lawfully imprisoned?
yes, Your Honor.
All right, so at some point you came in contact with a Joshua Treyfry, who was an employee there. Was he a CO or was he a custodian? Like, what was his job there?
He was a CO.
Okay, and did you assault him in some way? Did you push him, pull him, kick him, punch him, spit on NCR 6.302 B, C, and D? Miss Underwood?
It has.
And Mr. Steen?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Cobb's agreement to the low end of the guidelines, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the Michigan Department of Corrections for a pre-sentence investigation. So, Mr. Bomarito, you're going to get a packet. Someone's going to talk to you. They're going to prepare a pre-sentence report. Be truthful with them about your background, the events that occurred. They'll also look at your prior pre-sentence report. Ms. Underwood's really good about meeting with people within MDOC before sentencing, but sometimes MDOC won't let her schedule because they have other conflicts going on. So if she can't talk to you in advance, I will give her an opportunity to speak with you that morning. Ms. Underwood, are you available for sentencing on June 27 at 8:15 in the morning?
Yes, I am, Your Honor. Mr. Bomarito is at Ionia, where they actually do let me schedule telephone conferences, Your Honor.
So Ms. Holly, he's at Ionia. All right, Mr. Bomarito, you do have a right to be present in person for sentencing, or you can appear via Zoom. What would be your preference?
I would appear via Zoom.
Okay, I promise you we don't have as many cases on sentencing day, so it won't take as long. All right, so we will see you back via Zoom on that day for sentencing. And Mr. Bomarito, thank you for your patience this morning, and I'll see you back on that day. Thank you.
Can I ask you one question?
Sure.
Did you accept the Cobb's agreement or that's?
Yes, she did.
I'm gonna send you to the low end of the guidelines, whatever they are.
Okay. Thank you, Your Honor.
Thank you, Mr. Bomarito. You have a good day.
So.
Okay. Mr. Lee is next. So let me grab his file, put Mr. Bomarito's away.
Barbara, I might be better not showing up at all. False. Definitely show up. Traffic across all of YouTube is down the first 6 days of this month, so I need every one of you. Please show up. Show up twice if you can. Open another account and log in on another computer. I need everything I can get to beat the algorithm right now and to pull in viewers. Anyways.
Matter. So, Miss Underwood, how would you like to proceed with Mr. Lee today?
Can I speak to Mr. Lee for just a second, Your Honor?
So, Mr. Lee, I am going to pop you in a waiting room. We also have really good audio on Mr. Lee today. So, go ahead and join that breakout room. He went automatically. Mr. Sloan will be right with you. Miss Adams, I don't know how, but we're going to have to send notice or advice rights forms to Mr. Lee and Mr. Bomarito to get that signed.
Are those the same ones we use in district court?
No, they're the circuit court one.
They make a packet up, they take it to the jail, and they can just hand it to them.
Yeah. Yeah, so that would be great. So, Ms. Adams, Deputy Lucy will talk to you because I think we can send a packet over to the jail. Good morning, Mr. Dagger-Margosi.
Morning, Your Honor.
You have someone from MDOC. So are you done down in Judge O's?
I'm all done. I just have Mr. Oliveras here.
So we have Mr. Sloan, and so he'll be after.
Okay, thanks.
All right, well, they get that sorted out. Let's go say good morning to Judge Sheila Johnson in Southfield. She's got a pretty full courtroom this morning, it looks like.
On Street, Ypsilanti. They give me a little bit of his criminal history here. They said they couldn't verify any information. He has 2 felony convictions in the past 5 years. So he has to have a monetary bond pursuant to statute. And let's see, they list criminal record. Okay, so he's 28. You've been in and out of courts in jail and you're only 28?
Lost more time.
Yeah, 10 years, you're 18 from the time you were grown to now.
I'll do
Drugs? What drug?
okay.
How did you get yourself involved with cocaine?
14.
At 14? You just decided that you should put that in your body?
I had an older mentor who then I
Wasn't mentoring you, right?
at parties and U of M campus.
At 14? And so you went to college campus at 14, not as a student, as a trespasser, basically, too young for your drinking?
Drinking, started with drinking, then Xanax, cocaine, marijuana.
And what did you want to do with your life before you got?
Being the Marines.
That would have helped you. But you messed it up. See, this is a good lesson because this is what happens when you let somebody else tell you to do wrong. And at 14, it's not totally your fault because you're still young. But you do know right from wrong at 14. And you should have been strong enough to say no. But you weren't. And you were listening to an older person. And that older person, shame on them because they ruined your life from 18 to 28. But guess what? You're only 28. You could live to be in your 70s, 80s, or maybe even 90s or longer. Depends on how you're treating your body at this point.
Yeah.
You do have an opportunity to turn this around. Do you understand that? But you gotta want it. You gotta want to change. You gotta want it in your head and in your heart. And then you gotta say, drugs are out. I'm not, if you ever get out of jail, custody, at any point in time, you gotta ditch those people you were hanging with. You gotta stay home. You gotta focus on you. Education. Did you get any education?
I got a GED to understand the Department of Corrections.
Okay, so that's a start. So then you go from there and decide what you're interested in.
I want to be a counselor and help people who are in my shoes.
Okay, that's a good field too, but you might need to start by getting certified somehow. See what it takes to, maybe you can intern, maybe you can work under somebody in the substance abuse field and find out what it takes. Maybe you can go to community college. Maybe they have some counseling or social work degrees that you could get. You are fully capable of doing this, but you got to want it. And you can't do all that from jail, and you sure can't do all that from prison. So you have to keep yourself out of the system. I don't even know what this right here is about, because if you did do something, and don't say anything about it, but if you did do something, I'm wondering if the drugs are still a factor. because there is nothing you can get if you did it on a larceny from a motor vehicle. What is in the car that is worth all that? I mean, somebody could have left a coat, $10, $20, a cell phone. None of that is worth your future.
All right.
So you have to start respecting yourself, because right now what you've done is disrespected yourself by putting yourself in this position. Look at this long history. You want to go home and take care of your mother. I can't even give you a personal bond because you got too much going on. You've got from 2024 backwards through 2011 out of Washington State. I'm counting 1, 2, 3, 4, 5, 6, 7, 8, 9. Oh, this was dismissed. So let's start. 1, 2, 3, 4, 5, 6, 7. 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, resisting police, 22, 23, 24, 25, at least 26, at least 27 convictions. That's a lot for a young man. But if you can turn yourself around and put some years between this case here in 2025 and something that you're doing moving forward, somebody's going to take a chance on you. But you got to get your counseling certification. You got to figure out where you're going to go to school. You got to stay clean out of that neighborhood. You got to put that work in. Nobody can be successful without putting the work in. Because if you don't work in school, you're not going to pass. If you're not going to pass, you're not going to be successful. If you're not successful, you're not going to have a good career. You don't have a good career, you're not going to have any money. You don't have any money, you don't have a house or clothes or the things that you want. So it's a cycle. So you have to stay focused. And you got to start now. I don't care if you are in the jail. This is a good time for you to think about it. Make a list. Get your, I say, legal pad. They should give you one, and a pencil. Draw a line down the center. On the left side, write everything that's going wrong with your life that you'd like to fix. Then point an arrow to the right side of that line. And for each problem, write the steps down that you need to take to fix it. That's a fluid list. It may change daily. Some things you can do from the jail. You can check off. Other things you'll do when you get out. But the list changes. You check some things off. You add a couple more things. That's the list you pull out every day. That's your life path. If you don't have a roadmap, you're not going to get there. Your mom is at home sick. Well, do something that's going to make her proud. She has probably worried herself to being sick because of you. 10 years of this. So turn it around. Get focused on what would make you feel good and feel good about who you are and where you're going. And then that would then make her proud. Because when you look at your life, all you got is birth and death and what's in between. And what's in between matters. And your what's in between is not good right now. But that doesn't mean that you can't change it. Get a little faithful. And, when all else fails, if you're a believer, pray on it. Say, I need to be taken out of this little hole I'm in. I'm willing to do the work if you help me. I guarantee you're going to see a result there. I can't do too much with this bind. Mr. Shockley, you want to weigh in? Yeah, especially when pretrial services has said, 2 felonies within the past 5 years, under statute, monetary bond recommend. You have nobody to help post the 500?
I'm on bills right now. They're supposed to be on Zoom. I don't know if they are, but they're just hoping that.
Is there anybody on Zoom?
I think they thought it was 9:30. My phone, they missed it or something, but they're just hoping I'm something well.
Well, 500 is, for your record, 500 is low. All right. If I'm a lower just a little teeny bit more, but if I do this, you got to promise me that you're gonna do something once you get out, and even if you don't get out, that you're gonna do something to make a change. Because I can't care about you more than you do. Okay, so it's 5,010. I'm gonna take it down to 3,010. It's $300. All right, so you may not get in the Marines at this point, but you can act like a Marine, get yourself together, and be successful. So good luck to you. Matter is bound over. Fine is changed.
Okay, Axiom, thank you for the $2. I appreciate that. I would have said so earlier, but I didn't want to interrupt Judge. And I will apply that to Barbara's bail. So we got that going on. Zaiz, I am not an attorney. I don't play one on television, and I did not stay at a Holiday Inn Express last night. What I am is a guy who loves his country and who cares about our systems of government, and the court intrigues me for how it works and how it does not work. And the purpose of this channel is for all of us to not only be entertained, but to learn. So that is what we are doing here. Let's go back to Judge Anzalone for a minute. Judge Fleischer's been away from the bench, and I've got a couple other courts that I'm watching that are in recess at the moment.
Up to 1 year.
Anyone made any threats or promises to you to induce you to plead guilty to this charge?
Absolutely not.
Do you understand that if I accept this plea, you will be giving up any and all claims that, okay, and your attorney hasn't promised you any particular sentence or estimated what your sentence will be, Mr. Lee, has she?
No.
Okay, and it's your own choice to plead guilty?
Yes, it is. It's mine. I want to do this as soon as possible.
Excellent. All right. So, Mr. Lee, on October 4 of 2024, were you incarcerated at the Gus Harrison facility?
Yes, I was.
Say that again for me.
Yes, I was. I came in contact with an officer, Tenniswood, and we.
Oh, hold on, Mr. Lee. You got to only answer my question as we go, because I got to make sure I get the elements. So on October 4 of 24, yes, you were incarcerated at Gus Harrison facility.
Yes.
Okay, and you were incarcerated there due to being sentenced on a crime. So you were lawfully incarcerated at that time, correct?
Yes, I was.
And would you agree that the Gus Harrison facility is in Madison Township in the county of Lenawee?
Yes, it is.
All right. Now, you mentioned Brian Tenniswood. He was an employee there. Was he a correction officer? What did he do there?
The correctional officer.
Okay. And at some point, you assaulted him. So did you push him, punch him, kick him, spit on him? What did you do?
I elbowed him in his chin. No, in his cheek.
You say that again. You elbowed him. Where did you elbow him?
In his cheek.
In his cheek. Okay. All right. And you knew he was an employee of the Gus Harrison facility, correct?
Yep.
All right. Mr. Sneed, are you satisfied?
Yes, thank you, Your Honor.
Has court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Sneed?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I am going to refer this matter to the probation department for a pre-sentence agreement or a pre-sentence investigation. This court has made no agreement other than a COBS to the low end of the guidelines regarding any other possibility of a plea or possible sentence. In this case, with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Ms. Underwood, are you available for sentencing on June 27 at 8:15 in the morning?
Your Honor, the only thing I would say is it's shaping up that I'm having a lot of sentencing that day, both here and down the hall. Can we
Ms. Adams, can I move that out one more week, please? Or to the next available sentencing date?
Yeah, we'll see. It would be Friday, July 18th.
All right, so Mr. Lee, I'm going to set this for sentencing on July 18 at 8:15 in the morning. Where are you currently incarcerated?
He's in Ionia, Your Honor.
I asked him, what'd you say, Mr. Lee?
Ionia Correctional.
Excellent. All right, Mr. Lee, you do have the right to be present in person. Do you want to appear via Zoom or in person? I promise you won't wait as long on a sentencing day. We have less cases that day, so we're able to get you in and out. But do you want to appear in person or via Zoom?
I'll deal with the Zoom.
Okay, so I'll mark that down for via Zoom. Mr. Lee, someone's gonna reach out to you and do a pre-sentence report. Be truthful with them about your background, the events that occurred, and then we will see you back via Zoom on that day. Miss Underwood is really good and Ionia is really good about letting her talk to you in advance. So she will review that pre-sentence report with you. If for some reason, like maybe they're on lockdown or something's going on and she can't meet with you, I will give her a chance to speak with you that morning. So I will see you back via Zoom. What, Mr. Lee?
I have a question.
Okay.
Is it necessary that I go through the pre-sentence investigations process?
We're required by law to do that. I mean, you don't have to take part in it, but usually it's just you filling out a packet. So they'll look at your prior. Huh?
I'm not gonna fill the packet out.
Well, that's your choice, sir. So, Mr. Lee, we're also going to mail to you an advice of rights form that goes to the rights that I gave you today, and they'll have you sign that, and that'll get sent back to us, okay?
Okay.
All right, Mr. Lee, thank you for your patience today. You have a good day.
They were very taxed.
I know. All right, have a good day, sir.
Well, you got to admire that guy's honesty, if nothing else. He was the one who got impatient earlier. Let's go back to Judge Johnson.
Nobody's giving me the file. So what's Bridgewater, a VOP?
Mr. Bridgewater is supposed to be here for a trial.
Okay.
His attorney went here this morning and stated that Mr. Bridgewater was in the hospital.
Okay, well, this is case number 25-00349 SM. People State of Michigan versus Kenneth Bridgewater. And I don't know who his attorney is because Ms. Smith is his attorney, so go ahead.
Jennifer Smith, number 83034. I do represent Mr. Bridgewater as it pertains to this state misdemeanor matter.
Well, that's all I got right here. There's another one.
Following on the document today as well. Robert Trout on behalf of the people.
Oh, this is the misdemeanor trespass matter that you're representing him on. Give me that.
It would have been Jonathan Jones who was here this morning.
Okay, hold on. Mr. Bridgewater has 2 files. Okay, well, it's 2 on the docket. One says Smith, one says Solomon. So I don't have the 00253. Did you find it? Go downstairs and find it. I'm gonna need to call it. All right, so it's 25S 00253F1. Kenneth Bridgewater. All right, so on this particular matter, the trespass misdemeanor, Mr. Bridgewater scheduled today for a pretrial. There is a pretrial services report dated the 5th, indicating that he was enrolled on April 23rd. They went over bond conditions with him. He was advised to make an initial call to the system to continue doing so bi-weekly. They did get a check-in from him on April 30th. He was advised to call the number on the back of his insurance card or something. He was doing ETG once a week, drug testing once a week. He said he was already testing with ADCS for another case. So they sent a referral to that agency, and it was requested that testing be adjusted to whichever court had the higher frequency. They then emailed the facility asking for verification that he was enrolled. And that was pending at the time of the report. So he might have maybe done some things here. You've had no contact with him?
Your Honor, and indicate in the record, Mr. Bridgewater was here previously for his initial retrial on this matter and on the smaller case. On that date, he asked the court to adjourn the matter out slightly as they were still waiting on some discovery.
Yes.
I've received some, I think there may still be some audio visual still remaining. However, between our last court date today, I've not had any actual contact with Mr. Bridgewater aside from very limited communication. It's my understanding he was aware of this case and with his felony matter. AP shockingly indicated that there was an attorney here this morning who advised him that Mr. Bridgewater is in the hospital, which would be why he's not here today. There was no documentation that was provided this morning. This is new information from me. So I would ask the court just if we could briefly adjourn this out so I can try and make some contact with Mr. Bridgewater, see what documentation he'll have by way of maybe discharge papers reflecting when he was in the hospital. I don't think that he is not here for a reason that would not be warranted. Just based on the fact he was previously here, he was very eager to get these matters wrapped up. And that's all I have to report this morning, Judge.
So he didn't call you. What do you want to say about that request to adjourn?
Bench warrants are held for 48 hours. So if documentation comes in 48 hours, we can just recall the bench warrant. Over the years, I've dealt with this defendant multiple times. I have no reason to believe that he is going to come back based on his family.
Your Honor, if he's in the hospital, he's not going to be able to come to the court necessarily in 48 hours. If you don't know, there's
Okay, we'll give you a real brief adjournment
Thank you.
to come back and tell us what's going on. Next week.
Court's available May 12th at 9:30. Not available in the morning. Court's available May 14th at 9:30. That works and
Right, May 14th then at 9:30 for this pre-trial. So I guess we'll have to probably do the same thing for the felony because it doesn't make sense to have one warrant out and one not warrant. Okay, his bond is going to be continued at least till next week. And I know you will dig hard into it, Ms. Smith, and let us know what you can find. Okay, thanks. All right, so that's included. We'll call the felony if in fact we get the file. Oh, wow. Amazing. We think we've got it. Okay, so this is now case number 25S00253FY, People State of Michigan versus Kenneth Bridgewater.
Shockley, the rest of the people.
All right, and so this matter is scheduled today for a probable cause conference on the felony charges of resisting and obstructing or assaulting the police. It's a 2-year felony with a $2,000 fine. Count 2 has a misdemeanor, a prohibited use of a chemical agent, which was apparently ingesting nitrous oxide gas. 93 days, $100 fine. Ms. Solomon, Kathleen Solomon was the attorney of record. I do have a substitution that was recently signed indicating that Jonathan Jones is now counsel of record. Apparently, Mr. Shockley, you indicated that Mr. Jones did appear this morning and told you that Mr. Bridgewater was in the hospital somewhere.
That's right.
And so since we just adjourned his other matter, I'm going to go ahead and adjourn this one. Madam Clerk, could you make sure Mr. Jonathan Jones gets this adjourned, babe? And it'll be May 14th. We might not have time to mail it. So you need to call him at 9:30. And that will be for another probable cause conference. Case number M4513535A and that's AST, and then M4513535CSI. And these are both people of the state of Michigan versus Shaylin Phillips, spelled SHALYN.
Barb Shock on behalf of the people.
And good morning. What's your name? Okay, Ms. Phillips. Now you're present today on one count of operating with no license or multiple licenses. That's a 90-day misdemeanor with up to $100 fine. And then we do have a registration plate violation. It was expired. And that's a civil infraction, but it's already in default because you did not request your court date on that in enough time. So it went into default with a fine of $140 currently. So you understand that. And you certainly have a right to have a trial on the no license charge. It could be a trial by a judge or by a jury. And you're entitled to have a lawyer to represent you. If you couldn't afford a lawyer, you'd like to have a lawyer for today's pretrial and or trial, then the court would make sure someone's appointed for you. You understand that? Okay. Mr. Shockley, did you have any conversations with her?
No, Your Honor.
Okay. You have a couple of options. You could see what the prosecutor has to offer you. If there's a plea deal he might offer, you could consider it. You could ask to speak to a lawyer if you really just want representation. If you're eligible, we can adjourn it and get your representation, or you could set it for trial.
I have all my documentation and stuff I need.
Sure. We'll go ahead and let you pass it. Mm-hmm. Failure to appear. Okay. This is case number 21L00535FY, State of Michigan versus Alicia Stevenson. So who's that on Zoom? Do we have a file for that?
Barb Shock on behalf.
Charles, do we have a file for the Zoom case? And Mr. Stevenson is scheduled today for a show cause hearing for failure to pay fines and costs.
It's the woman on Zoom.
Okay, we'll do her next. And so it looks like he owes the restitution, so they say. And this was scheduled for 9:30 and he's not appeared. 11:25. The underlying charge here is malicious destruction of a building greater than $200, less than $1,000. So we're going to issue a warrant for his arrest. The bond is going to be $1,650 cash or surety.
Who was that, Your Honor?
That was Miss Alicia Stevens.
Let's head over to Judge Middleton. He's going to be doing some sentencings, it looks like.
This is file number 25446, People versus Mariah Wyrick. Attorney Stephen McLaughlin is here from the Hills Law Firm on behalf of this defendant. And once again, Mr. Gabriel is here, and this assignment fell to Daniel Frazine. And this is a tough one. I did get the police reports. Daniel had them, but I couldn't access them. I got them yesterday. The defendant has no criminal record that we can discern, and she got charged with operating with a high blood alcohol level, pled to operating while intoxicated first. These are bad facts. And that's all we've had lately, Mr. Gabriel. It seems like all we have are bad facts. Both in our statute cases and our ordinance cases, we had several, including the one we just didn't do. Very bad circumstance. Good morning, Mr. McLaughlin. What would you like me to know here?
Thank you, Aaron. I'd like to begin if I could present to the court a letter from the Community Healing Center. It's authored by Aaron Masterbrook. I've showed this to the prosecutor, and what it will indicate to the court is that Ms. Wyrick has continued to attend counseling sessions since she underwent her substance abuse evaluation. I know that the court looks at a scoring system, and on the scoring sheet, it has her at 4 such counseling sessions, which would subtract 8 points. The sheet would indicate that she's attended 5. And I think that additional 2 points that would be subtracted under the sheet is significant because it takes her down a grid, because it would put her under 50 points, which would put her at an A3, not an A4, which would lead her to a range of 5 to 7 days, as opposed to the previous 16 to 20 days. So I'd like to begin my allocution by just acknowledging that there are bad facts in this case. It was a high BAC case. There was THC found in her system, amphetamine found in her system. There was an accident. Thankfully, nobody was injured in that. But I would also submit to the court, I think that Ms. Wyrick has done what we would want somebody in her situation to do once this event occurred. She went to an inpatient treatment center in Florida for a week. We sent you the certificate indicating she successfully completed that program. She came back and has been counseling with the Community Healing Center, the letter I just submitted to you, and she's been following through with her appointments there faithfully. She's also been going to AA meetings, as is documented in the pre-sentence investigation report that was provided to the court by probation. So she has taken very seriously the issues that presented themselves when she had that accident and talked to the police and learned that she does have a substance abuse issue with alcohol and has taken substantial steps to deal with that. I would ask the court to follow the recommendation that is in the report that was sent to the court by the probation department. It does ask for 7 days jail credit for 1, with 6 of those days being deferred. I think with the adjustment to the scoring, that falls in line also with that sheet. 24 months probation, that she undergo alcohol or drug testing at the discretion of the probation officer, that she continue to attend AA meetings or a 12-step meeting once a week and complete successfully complete her counseling with the recommendation fines, costs, and the cost reimbursement. Thank you.
Mr. Gabriel, you have any input on this one?
Your Honor, I did have an opportunity to review the police report, and I also watched the video on the body cam. I think my biggest concern is that I was somewhat surprised when I saw how high the BAC was and how well Ms. Wyrick actually kind of did. I mean, it seemed to me that there clearly was a high tolerance of alcohol built up. She was able to function. She was able to run through the sobriety test, although not really great. However, Your Honor, that being said, I also am aware from some of the documents, and I don't want to go into detail regarding this, you know, to the world, but she's been going through some significant changes in her life and readjusting. And this particular night, she had an opportunity to go out and maybe enjoy a little bit of time for herself. Unfortunately, it ended up in this way in jail. A long time ago, when I would come here as a defense attorney, I used to hear the court say that the court believed in one day drunk, one day sober, as far as a way to try to impact what could happen in the future. I think that kind of a situation would be appropriate in her case, as long as she continues to work on her sobriety, continue to be abstinent, and take care of her family. That's all I'd ask.
Thank you. That was the policy here for many, many years under Judge McManus. And then we inherited it, Judge Welty and me and others. But the world's changed since then. You can't have a hard and fast policy like that anymore. And we're not. Plus the law changed. There's a presumption of no jail unless the facts are aggravated. And now we're supposed to also somehow apply proportionality in our misdemeanor sentences. But yes, that was the policy here for a long time. Judge McManus's theory was they slept through the first night, and maybe the second night would hit home. All right. Mr. Frazine, like I said, you got this, and I think this defendant has done as much as anybody we've seen so far this year. I think some of that, the Hills firm is good at getting people plugged into services prior to sentencing, but I think a lot of this she did on her own. What else would you like me to know, Daniel?
Well, you know, obviously these are some pretty bad case facts, as we've all acknowledged this at this point, and she has done an awful lot, and probably more than most. But I will also say it's one of the worst case facts. The only thing that could have made it worse was if somebody was seriously hurt. The accident was obviously pretty substantial. Had the severe damage to the front end. Best of my knowledge, I don't see it was an accident, but the police said they heard a bang, but it looks to me, as far as all the paperwork I have, they never did an accident report. That's one of the reasons why I asked for 200 and not 255, because they didn't really do anything additional for this other than a drunk driving and get her blood drawn. I think she has a lot of stuff that she has to deal with from early on, as well as some of the stuff that Mr. Gabriel mentioned about some of the stuff she's struggling with now. I mean, when you look at somebody that tried alcohol when they were 6 years old, that's probably the youngest I've ever had someone admit to. I've had some 8 and 9 year olds, but I've never had someone say their first taste of alcohol was 6 years old. She had a rough upbringing, but it doesn't excuse anything. She also has 2 children that she is solely responsible for, which again is not a get out of jail free. I think, as Mr. Gabriel alluded to, she has a lot of responsibilities, and she has had some struggles in the past. I think she may have been doing a little bit better, but not good with the alcohol for sure. And this night things just went crazy. She has no recollection of taking anything. I don't know how well she could recollect at a 232 when you're talking 23% of your blood's alcohol. I do think she's willing to do whatever she has to do. And for her sake, the sake of the community and her children, I structured this the way I did so that I could just monitor for a while, make sure she stays with therapy. I think that's going to be the key to her success, is staying in and dealing with some of the stuff that she has not dealt with in the past, Your Honor. That's all I have.
Ms. Wyrick, I don't know you well. As I said, you don't have any criminal history. Of course, I knew lots of Wyricks. And you know, here we are this morning. I think what you were doing was grieving, but you weren't doing it very well. You were grieving with the assistance of alcohol. And I think this was a great big wake-up call for you. As Daniel said, you got to be here for your kids. And I think he woke up the next morning and said, I can't do this anymore. What was your maiden name?
Carl's.
And which Wyrick were you married to?
Andrew.
Who was his father?
Theodore.
All right, I knew Ted for years. Is that why you guys are here?
I'm her mother-in-law. Introduce myself.
Okay,
I'm her boyfriend.
all right. Well, it's good to have support. Andrew is your son. I didn't know that. You know, I probably knew it 40 years ago, but so there's a lot of grieving going on. And, but you went into inpatient. Once upon a time, inpatient was 30, 60, 90 days. A, that's very expensive. And B, you can't often just have people put their life on hold when they have children for that amount of time. So you did that, you came back, you're plugged in with Community Healing Center, and you have an individual counselor, which is important. What AA are you going to?
I go to the one in Vicksburg. It's the one that's the most local, that is every day.
Well, a lot of our people here like the Vicksburg.
Mhm.
The Friday night one was the big one.
That's the one I try to go to. the most.
And plus Vicksburg's a nice little town, and some of our people use it. And a guy I knew was really plugged in over there. He liked it a lot. So is there anything else you'd like me to know?
Well, I understand the gravity of my actions. I'm truly am disappointed and disgusted with myself and those things. The soberness that is gives me gratitude. I sit here 102 days sober, and I am a better mother every day for my children because of it. So while I'm here to take my punishment, I understand what I did was wrong to my core. I'm thankful for that opportunity to be where I am right now in my sobriety.
And it takes a lot of introspection, and you've done that. In this case, the officer, sometimes they say, well, where's a policeman when you need it? This happened right in front of the policeman. He was parked there on this west side of Sturgis, and he heard you before he saw you. He heard bam, bam. You hit a mailbox and you hit a 45-mile-per-hour road sign, which I don't think did much good for your car. One thing I tried to discern, which I don't know if I was able to, is where were you coming from?
White Pigeon.
Where in White Pigeon?
I was at a friend's house.
All right, we get a lot of cases out of the Tomahawk where people are coming from there. You weren't in a bar, you were just with a friend?
Yeah, it was like a friend's house party.
Well, it's not a very good friend that lets you leave like that.
No, I mean, we were arguing because I didn't like who was there, and I had just said I just wanted to go home and go to bed.
And what I also really didn't like is methamphetamine or amphetamines in your system.
Mhm.
That is the absolute last thing you need in your life.
Mhm.
Makes all the lights go out. turns you into someone you never were. And it's very hard to come back from that. But we got 102 days sober, which includes no drugs and no alcohol. You also were smoking marijuana or using a THC product, which is lawful for adults. A high percentage of our drinking driving cases, they also have marijuana in their system. We don't even know how to understand it. They tried to set up a standard for how much marijuana was too much. And the state police said the Department of Public Health has to do it. The Department of Public Health said the state police have to do it. And basically they couldn't figure it out here or anywhere else. We have a standard for OUIL, 0.08 or above. We don't. Now, surprisingly, you got a plea to impaired, which is very generous under the circumstances. But impaired driving will allow you to keep a restricted driver's license to drive back and forth to work, as opposed to an outright suspended license. So I don't really object to that so much. The punishment, whatever we're going to do, we can do in the context of that. And Mr. Frazine says that he just wants to keep an eye on things, and I guess I agree with him. You're doing everything you need to do right now. And it's sometimes easy to relapse. There is a physiological phenomenon that at about 120 to 150 days, you get sort of a rebound effect and your body gets a giant craving for alcohol. So you need to be cognizant of that. Out of the blue, it might hit you.
I do find like I've had moments of that happening, Your Honor, and that's when I immediately I go and I'm planning to go to a meeting when those happen.
Well, that's the one solution to that. I'm going to do a 24-month probation, which doesn't mean you're going to be on probation for 24 months. It can be discharged at the end of 12. Now, I'm going to follow the recommendation, but a little modification, as your attorney argued. I'm going to order 5 days jail, credit 1. 4 days are deferred. So we're going to monitor it. I forgot where you're employed.
Community credit union.
That's right. So you got a good job, but this is expensive. You had to hire an attorney, you had to go to Florida for treatment. And there's more, but you got time to pay it. A $75 crime victims' rights fee, a $50 state minimum fee, impaired driving care is a $300 fine. I'm going to cut the screening fee in half from $100 to $50. There's no attorney fee. You hired your own lawyer. Probation oversight fee is $960. That's $40 a month for 2 years, but you'll, in all likelihood, probably be discharged at the end of 12 months, which would cut that in half. Daniel, you didn't order the victim impact.
She did MAD.
She did MAD?
Yeah, she did MAD VIP.
All right, and police reimbursement is $200. Like I said, you've done as much as anybody so far in 2025. And maybe the prosecutor's bet on an impaired here was a good bet. Total 1635. Could be reduced by 480. There is no bond. That's 2 in 1 year. Drug and alcohol testing as directed, substance counseling and treatment, sign a release. Support group. Like AA or Celebrate Recovery. No drugs and no alcohol includes marijuana. Right now you need to be on top of it all. And one substance sometimes can lead to relapse in the next. I don't think methamphetamine was a thing I don't know what was going on the night you were at this place, but don't go down that path. We'll lose you to the dark side. I think you're gonna be an ideal probationer. The guy that didn't show up ahead of you, he got arrested for drunk driving 3 times in 12 months. I have 3 young men from Sturgis who aren't even 21 yet. And they've already got 2 drunk drivings. And all 3 were accidents where people were almost killed. You're not 21. You've got more life experience. You're a parent. This is your chance to have a better rest of your life. And your kids. I'm gonna see your old partner, who's now a judge in Kalamazoo. I don't say his name here, but I'll see him tomorrow, maybe tonight. And things like seems to be going pretty well for your firm. All right, I'd like you to take this downstairs with Daniel. He's gonna get you plugged into this probation. Mr. Gabriel, thank you for being here. I'll make this part of his file. All right, Ms. Wyrick, this will be a case of no news is good news. If I don't hear anything about this, I'll assume it's going well. And congratulations on 102 days worth of sobriety.
Thank you, Your Honor.
Thank you, Dan. Daniel, do you need this?
I can hear it.
All right, hopefully she continues to get herself together. Let's go back to Judge Fleischer.
I can't tell you how many people we've had here that continue to take the pills, continue to take it because the tolerance builds up and you end up killing yourself because you put your lungs to sleep. That's what you do. Not to mention, how are you? It's expensive to even do this. How are you even getting the money to do it? Are you working?
Sorry.
What do you do?
Reception.
Did you graduate from high school?
Yes, sir.
He's living with you now?
Yeah.
Okay. While he's on probation, he must stay living with you guys. Okay. And I think that it's probably a good idea to have a curfew while he's on probation so that he's not out in the middle of the night. You are not allowed to hang out with any of your old friends. You know, you hang out with the wrong crowd, you're going to end up doing the same thing.
We currently have no other curfew.
Now it'll be a part of the probation though, so that he has to adhere to it. And will adhere to we can make it a condition. Anything that you want, we can put it on there as well. So no weapons. If you know of a certain person that he's not supposed to hang around with, let us know. We can make that a part so he's not hanging around with these people. Can't go out at night, no going to any parties, no going to any bars. Hanging out with people who are either convicted felons or of a bad character. So I will let you guys get with Shatoria, you let us know, and then we can make it any kind of anything. What do you think is the appropriate time he should be home?
So we've had him on during the week, a 12 o'clock schedule.
At midnight?
Yeah.
Oh, no.
That's only because.
Work.
He works.
Get off
with
at
a
11.
girlfriend.
Well, Houston Community College doesn't stay open until 11 o'clock.
But
So,
he has a
well,
lot of
afterwards.
girlfriend. But he, so his girlfriend,
Yeah, but afterwards, like last week with the events, some days we'll stay after.
not often, but there are
Not every-
times where they have events. But typically the building department.
You will have to show what the event is, the time that it ends, and then you get approval. But 10 o'clock is your curfew. I don't want you to 10 o'clock. You take baby steps to earn trust. Trust isn't something that we just give to you. You have continually broken our trust. So I don't want you to do anything to drive you back into the old Mr. Rooker, because it's unacceptable. And the only thing we want is we don't want you to kill yourself. That's all we want. Everyone here, you have a lot to live for. Life is great. You know, the more money you have in life, the better life is. You get to buy nice things. You get to take nice vacations. You go on a cruise. You go, you know, wherever it may be, Hawaii, wherever it may be. But that only happens with money. And you get money with education and with knowledge, not what you've been doing. The agreement that you have worked out is a 13-month deferred. This is a type of probation that, like I said, if you complete successfully, you do not end up with a conviction on your record. But like I said, you give up the right to a trial, compel witnesses to testify on your behalf, confront, cross-examine your accusers, right to be arraigned. You give up the right to appeal. So once you enter into this agreement, you are stuck with this until you either complete it successfully or you violate. You violate this agreement, I'm going to issue a warrant. I'm going to put you in custody, bring you back out, and we're going to talk about what you did to violate. And if you could be looking at an entire year. Do you understand? For you to complete this successfully, you must do a TRAS. This is an evaluation to see what other conditions you may need. If they assess supportive outpatient treatment, if they assess inpatient treatment, I don't know. But you understand. No drugs, alcohol, random testing, $100 one-time donation to the family violence provider. You just do Houston Area Women's Center. No weapons, and no harassing, threatening, or abusive contact with Guajardo. Curfew 10 p.m. to 6 a.m. You must also do what's called the Batters Intervention Prevention Program. This is an 18-week class that you must go once a week for 18 weeks. Do you understand? The worst possible thing you can do is just take off. That's an immediate warrant. We can always work through any problems. And it's never about the money. I don't care about the money. It's you doing what you're saying you're going to do, staying out of trouble, and be nice. It's not hard, especially with these probation officers. You go to a probation officer, you make your appointment at 3:30 in the afternoon, you go over there, they're already going to be stressed out because they deal with all these other people. You go in there with a bunch of issues, it's probably not going to go well. You understand? Anything else you think that we should address? I'm going to waive all the fees, so it doesn't have to pay for anything. With regard to if they do any kind of like intensive outpatient, I'd like to try to qualify for, funding.
Yes, sir.
We're going to try to keep everything to a minimum as far as money, but you test positive. Do you understand? I want him tested today, and then let's test again in 50 days.
Okay.
I'm testing you again in 50 days. If you test positive for weed again, you know what happens. Do you understand? How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty, Mr. Rooker. I'm going to withhold that for 13 months. As part of this agreement, the assault is going to be the assault is dismissed, right?
Yes.
All right, Mr. Rooker, I wish you the best of luck. Make it work. Okay? All right. Thanks.
Thank you. Electronic money.
So yeah, I'm going to take a look at that interaction this afternoon. That's probably a video in and of itself. They were talking several minutes before I was able to cut to it, but I didn't want to interrupt the sentencing that we were watching and Judge Middleton either. I'm going to go ahead and call it a day just a few minutes early today. I've got other matters that I need to tend to, and the quicker I do that, the quicker I can get to reviewing some of these things and bringing you more content later today. And this seems like a natural breaking point anyways. Do me a favor on the way out. If you have not smashed the like button, please consider doing so. If you are not already subscribed to the channel, and I've earned it today, please do subscribe. In the pinned comment in the chat, there are 2 links. One is to our newsletter. If you are not already signed up, I would encourage you to do so. That newsletter will be starting up here in a week or two. If you think I've earned channel membership, it's $2.99 a month. It's inexpensive, and we give lots of good extras, and probably going to add another extra here in a few days, but more on that to follow. But yeah, if I earned your membership, that would be great and certainly appreciate it. And that $2.99 goes right back into the channel. None of it goes into my pocket. It just goes to making things better. Yeah, be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. I hope you all enjoyed the day. Bailey, Kazman, Ashley, thank you. Thank you for joining us. Appreciate it. And we'll see you tomorrow. Take care. God bless.